Hey everyone, today I'm going to talk about maternity leave in Singapore. Before we start, there are two categories of employees who are entitled to maternity leave in Singapore. The first fall under the Child Development Co-Savings Act. These are for mothers where the child is a Singapore citizen. Where the child is not a Singapore citizen, the entitlement will be found under the Employment Act. Under the Child Development Co-Savings Act, an employee, which includes managers and executives, is entitled to maternity leave benefits if the child is a Singapore citizen, the child's parents are lawfully married, so no single parents, the employee has worked for her employer for at least 90 days before the child's birth. So if you work for 1 month before that, too bad. Now, what is the entitlement for an employee who falls under the Child Development Co-Savings Act, i.e. the child is a Singapore citizen? Well, she's entitled to 16 weeks maternity leave. The maternity leave of 16 weeks is split as follows: 4 weeks immediately before delivery and 12 weeks immediately after delivery. So the total is 16 weeks. So the employer and the employee can mutually agree, they have to both consent, they can mutually agree for the employee to take the last 8 weeks of maternity leave, that means the 9th to 16th week, flexibly over the 12-month period commencing from the child's birth. So I will now talk about maternity leave under the Employment Act. Under the Employment Act, it provides that mothers will be entitled to 12 weeks of maternity leave if she has less than 2 children of her own at the time of delivery, she is employed for less than 90 days before the date of delivery, and obviously her child is not a Singapore citizen, so she falls under the Employment Act regime. She's not entitled to 16 weeks, but she's entitled to 12 weeks. So she will be paid by her employer for the first 8 weeks of maternity leave, if she has fewer than 2 living children, and she has served for at least 90 days before the birth of the child. The last 4 weeks can be taken flexibly over a 12-month period after the child's birth. I will go on to talk about dismissal, that means firing, sacking the female employee because of maternity leave. There are some naughty companies who do that, sack the female employees because they don't want to pay the maternity benefits. Under Section 81 of the Employment Act, you're not allowed to fire an employee during the period of her maternity leave, or on a day that the notice will expire during her absence for maternity leave. Section 84 of the Employment Act provides that if you fire an employee without sufficient cause, that means good reason, during her 2nd trimester, her rights to the maternity leave will not be affected. That means you still have to pay her. Section 84A of the Employment Act provides for firing of female employees on the grounds of redundancy. Under Section 84A of the Employment Act, if you give notice of dismissal, that means you fire the female employee on the ground of redundancy within a period of 3 months before the estimated delivery date, or within a period of 3 months before the date of a confinement, the right to maternity leave is not affected. In other words, if you fire her on the grounds of redundancy during this period, during the 3rd trimester, you still have to pay her the maternity benefits that she would otherwise have gotten if you did not fire her on the ground of redundancy. So thanks for watching this video on maternity